It's an interesting topic we're dealing with because it probably has caused more confusion around the space than anything else. And the fact is that Bitcoin was the first use case for the blockchain. But watching what's happened, it took a long time to even sort out what that first use case was all about. Everybody said, oh, it's a new form of money. It's, this, it's that. Well, it took us about 3 or 4 years to really get to the point we could even say, wait, we've got two different concepts we're talking about. One is money, and one is rails over which value will transfer. And then more recently, and I think probably dating back to late 2014, early 2015, anyone who had Bitcoin in its name seemed to try to get rid of Bitcoin because it affected all aspects of trying to bank, trying to get serious attention in various corners, so that we've then moved to the blockchain. So what we're going to talk about today is really taking a deeper dive on, what does it mean to be money, and how is that really a distraction? And I don't know whether to interject my personal views right now or not, but I'd like you to think hard about how maybe distracting it is as we move forward into this next phase of exploring all the different kinds, or at least more of the potential use cases. So with that, I'd like to start with our government representatives to talk about their perspectives on these issues, and how do they come to the table? What does Bitcoin mean for them, and I guess broader, the blockchain? So why don't we start with Helen?
Sure. I'm Helen. I'm an attorney at the FTC, and I focus on financial technologies, and that includes crowdfunding and virtual currencies. In terms of how the FTC looks at it, at Bitcoin and other types of virtual currencies, we are focused on consumer protection. So what we want to look at is, what does the consumer see, how is the consumer using it, and we think that basic consumer protection principles always apply, no matter what the technology is. And it's just fundamental principles of fairness and disclosure. So depending on where the consumer is using Bitcoin or other types of currency, we want to make sure that initial platform is clear, where if you're telling consumers you're charging a fee, that's adequately disclosed, and where consumers just aren't surprised.
And Rose, from the CFTC's perspective?
Yes, just like Helen, my name is Rose Troya, and I work at the Commodity Futures Trading Commission, acronym CFTC. My usual disclaimer, of course, is that any discussion here that I say are my views alone. And
Me too.
She just saved you.
Yeah. So I don't want to bore any of you here, so I'll keep it short, because I know after lunch everybody's kind of falling asleep or maybe wanting to go back for seconds. In any case, at the CFTC, we are very much into the infancy of regulation of blockchain and Bitcoin. It has been ruled or asserted in 2015 that the CFTC will define Bitcoin as not as a currency, but rather as a commodity, and just like silver and gold. And for those of you who do not know what CFTC does, it is a commission that regulates futures options on things like silver, gold, natural gas, electricity, and financials as well, foreign exchange, for example, and even the derivatives of securities. So our sister organization is the Securities and Exchange Commission, and they primarily focus on securities. And we're at the other end of the other side of Washington, and we regulate that. We've been doing the Dodd-Frank Wall Street Reform Act of 2010 since 2010, 6 years ago. And Bitcoin and blockchain have only come into our kind of venue in the past 2 or so years, even though it started up in 2008. In terms of regulation, Europe, for example, the European Court of Justice has ruled that Bitcoin can be used as a currency, and they can use it just like a euro, and they can tax it. Whereas the U.S. is a little unclear as to where it will go, given that before we already heard the last few panels talk about the ruling in Florida, where they don't deem it as a monetary or financial instrument. And then, however, blockchain can be used for settlement and clearing, and it's a great technology. However, we will be seeing that in Europe, for example, Euroclear, which is a large settlement house, will be using or harnessing the ItBit technology for settlement and clearing for the London gold market. And with that being said, I'll turn it over to the next.
Well, and I'd like to turn it next to Peter. I know, Peter, you've been dealing with the definition of Bitcoin in multiple circumstances. The Florida case was just mentioned. Can you give us sort of a sense of the other areas we've seen the issue of what it is come up?
Sure. So looking at this from the standpoint of a technologist, sometimes it can be frustrating that you don't get a clear answer as to what Bitcoin is from people who may or may not be regulating it. I think sometimes people expect one particular ruling or one particular agency interpretation to be the be-all, end-all, and then we won't have to deal with these questions anymore. And that's simply not the case. So regulation is activities-based. This is the way regulation of anything works. So it depends on what the person is doing with the thing, not what the thing is per se. So in the case of the CFTC, what we saw with that ruling was that, okay, we're going to say this is a commodity because people are trading derivative financial products built on top of it. They're doing futures, they're doing swaps, they're doing margin trading on exchanges. And those are things we traditionally regulate in the context of, say, pork bellies and futures on pork bellies. And so we're going to say Bitcoin is a commodity. But that's for the purposes of the CFTC. That's how you assert jurisdiction, generally, and that's how you then ensure that the higher level financial products that people are trading built on top of the commodity are traded on fair exchanges and safely without market manipulation and other things like that. And then the FTC will look at this from a different perspective. Helen was involved in the Butterfly Labs case, which is a really interesting case that sort of tangentially touches Bitcoin. In that case, you had a company that was selling mining rigs, so computers that would, if you bought it, you're going to earn Bitcoin. Congratulations, you're part of the network and you're going to get a return. The thing is, mining is a very competitive industry, and if your computer's not up to snuff as far as the state of the art, you won't earn much of a return. And Butterfly Labs, they promised some really great specs on their machine and said you're going to mine a lot of Bitcoin if you buy this machine from us. And then they didn't deliver quickly. They took a long time to deliver, which meant that when you finally got the machine, it was not competitive with the Bitcoin network. So this is not a case of the FTC saying, we've got jurisdiction over Bitcoin. This is not a case of the CFTC saying we've got jurisdiction over Bitcoin. This was a case of some consumers who were harmed by basically a delivery date scam, just as you might see in any other normal consumer product that was offered, say, online or in a crowd sale or something like this. And in the CFTC's case, you have places that are actually trading, leverage, margin trading of an underlying asset like Bitcoin, and this is an area where we want investor protection. So what to a non-legal person or a non-policy person seems like sort of a cacophony of ruling after ruling, and we also have the IRS says Bitcoin is property. FinCEN at Treasury says Bitcoin is a virtual currency. They don't say it's a currency, but for them a virtual currency is something that exists, and that places it under their jurisdiction for anti-money laundering purposes. You're going to see this and this and this and this, and it may be confusing, but this is the way we normally figure out how we're going to have regulators meeting their policy goals or their statutory objectives when a new technology has emerged that presents a new wrapper, if you will, to do the same old things.
And I just want to jump in, the FTC's point is that it doesn't matter, actually, because we're looking at consumer protection and we're looking at how consumers are engaging it. I think Peter put it in a really good way. Regulation is activities-based, and that matters for a lot of other agencies on whether or not how you define it. But for us, if this is something consumers are using, we want to make sure that what you're providing meets the consumer's expectation. So when you have something new like Bitcoin and people are using it to buy things, if there's a gap between consumer knowledge of what they're expecting and what they're actually getting, we want disclosures. We don't want consumers to be surprised that they're being charged, or if they don't know that certain exchanges don't have different types of disclosures. We just want to make sure that consumers know what they're getting into.
Well, one of the things that we see is, you have to be careful what you ask for. And when Bitcoin hit the scene in really, I think, awareness in 2011 timeframe, everybody was talking about it being money. Well, under our laws, how do we regulate people who handle money? We typically regulate them under the banking laws, or under money transmission laws, if it's non-banking entities holding those funds. And then sometimes if it's being handled by securities firms, then it'll be under the securities regulation, and likewise for the commodities. But what we saw was an initial burst of focus on the concept of money and the application of state money transmitter laws. And when you get into that world, we know it can be very, very messy. Before we go back and talk a little bit more about the state level, I'd like Brian to sort of talk about, with 50 states on money transmission alone is quite a mess, because we don't find a lot of commonality between those states. And then add all of the other pieces of the pie here. What are we supposed to do?
I mean, you're absolutely right. And it's funny that when we talked about, is this a distraction? Because I often wonder what would happen if the first use case for the blockchain was, this is going to compete with a database. It's a better way to transmit information among different parties, confirm it's accurate. And then someone later came on and said, I could build a currency on top of this. How would our regulatory trajectory have changed? But because the initial use case, and the biggest use case, at least so far, is something that seeks to compete with traditional money, then you run the risk, as you mentioned, of this being, this sort of born into being regulated or potentially regulated in the shadow of state money transmitter laws, which is, a potential challenge, because, as you say, there's not a lot of consistency between the states. Congress has asked, for consistency in the past, and the Uniform Law Commission has come up with a uniform law, and I think 7 states have adopted it, which means 43 haven't. If my numbers are right. You have a situation where you have a lot of diversity, you have a lot of uncertainty, and then you layer on top of that the uncertainty of, well, does this count for money transmittal? And some states have come out and said, no, it does not. New York has come out and said, well, we're going to create a completely bespoke system, and that will apply. And then, as was mentioned, the Florida case, the Florida law enforcement seemed to think that the Florida money transmittal law did apply, and at least so far, the courts have disagreed. So if you are in, and I should back up for 1 second to tie this together, which is that because of the way, as I understand it at least, and I'm not the expert on this panel on the technical aspects of it, that you can make an argument that transmitting data through the blockchain is like writing a contract or writing a report on a $20 bill, and then sending it out. What's important there is not the $20 bill, it's the information or the legal document or the rights that are conveyed on the contract or whatever, but you're still transmitting money. And then the question becomes, well, if we want to use this technology for non-pure money transmittal purposes, but we are using a token that has a value and is treated by some people as money, are we going to have to apply or deal with state money transmittal law? And if we are, how confident are we that we understand the application? How confident are we that the application is going to be durable? And that's a big question not just at the state level, but also at the federal level, where there is at least the potential of criminal liability for operating a non-licensed money transmittal business. And whether or not a prosecutor would necessarily ever bring a case in that regard, it's probably not something that people want to be, thinking about late at night.
Right, and just to add, this kind of goes to what you're saying about the original sin of money. When a technology is suddenly dealing with money, you're dealing with sort of a different ballpark from a regulatory standpoint. So the confusion that's unfolding is in many ways analogous to, say, the confusion that has unfolded at the state and local, mostly local level when it comes to ride-sharing services like Uber or Lyft. You say, well, all right, there are people now driving around and they're all connecting using an app to the people who want to pick them up for rides. Is Uber, by providing this service, actually providing a taxi service? Are they the kind of entity that needs to be licensed by a taxi and limousine commission? Are their drivers that kind of entity? These are difficult questions because the technology has enabled something new that does an old activity, basically. And then we have to figure out, all right, does Uber then need to go seek permission? Can they just seek forgiveness? That's a strategy that they choose as a business, and in many cases, they've only sought forgiveness. It's a different matter in the case of money because the scale and the seriousness of the regulations at play are different. It's a difference in kind. As Brian mentioned, there are federal criminal statutes that say if you are engaged in something that a state considers money transmission, and you do not have a license to do that money transmission in that state where a license is required, that's a federal felony. And that is a portion of the Bank Secrecy Act that was amended by the Patriot Act that is very severe, to be entirely honest. Now, we can talk about whether it's proper for that kind of regulation to be severe, that criminal statute to be severe, because we worry about, say, money laundering or terrorist financing or things like that. But this is a criminal statute that has no knowledge requirement. So even if you didn't know that you were doing something that Alabama considered money transmission, even if you didn't know that one of your customers on your website was from Alabama, even if you didn't know any of these things, that you needed to get a license, you could be held liable. And actually, that particular criminal statute pierces the corporate veil. Your investors are potentially liable for 5 years in prison, potentially. And, will a prosecutor go after somebody who's a good actor, who was not doing this out of any malicious purpose, maybe was doing something non-financial that incidentally transferred money? Because there's no de minimis threshold that says that transaction was too small. It's not money transmission. No state law has that de minimis threshold. So the stakes are high, and it's because of the presence of money. And so you want an internet of money. You think, it's silly that I have to wait so long for my bank to connect to another bank to transfer. I could just do more fluid transactions and all these things. You want basically what Uber did to the Taxi and Limousine Commission. But it's a lot harder to do it in a regulatory sense than it was for Uber.
And the stakes are potentially very high. Is Drew still in the audience here? Because I wanted to ask him. His friend was the defendant in that Florida case.
Espinoza case.
The Florida case, there are two pieces to the statute that both Brian and Peter have been talking about. It's 18 U.S.C. 1960. And you are guilty if you're acting as an unlicensed entity, if you need a license in a state, but you're also guilty if you're acting as an unregistered money service business, which is a federal concept. So you can violate the state law by not being licensed and violate the federal law by not being registered.
With FinCEN.
With FinCEN, right. And what's interesting about the Florida case is that they focused on whether he was licensed appropriately under state law, but they never addressed the issue of whether he was registered under federal law as a money service business. And it could have been a very different case had it been prosecuted by the feds instead of the state officials. But it is that we've got a great example of a situation, and there you've got a single trial court judge in a system where there are, 12, 11, 13, something like that, trial court judges around the state of Florida. Their ruling is not binding in any way upon the regulator who's responsible for interpreting that statute. So it does leave a lot of problems and holes for us to deal with on a going forward basis. And as Peter alluded, I think, or I mean more than alluded, but your point was very well taken about as we're moving forward with the blockchain, I guess the question is how much Bitcoin are we going to need to make the blockchain work? And are we going to be involved with various blockchain applications, whether it's supply chain or otherwise, of moving value that we're going to have to be continually concerned on a going forward basis with this issue?
So blockchain means a lot of things to a lot of different people. And there was a panel earlier that got into a lot of that, which we don't need to rehash. But the long and short of it is, I don't know of a system that is open, that allows anybody to participate in the consensus. So what we're talking about are systems where people come to an agreement about something. It's a source of truth. I agree that you transferred this many Bitcoins to you, and you're going to be referenced by a number, not by your name, but we all come to an agreement as a network that you transferred this many Bitcoins to you. No matter what, we're generally talking about that. We're talking about multiple computers coming to agreement over some sort of calculation, over some sort of change in a ledger. Maybe it's not money. Maybe it's, I agree that you have access credentials to call into this server. I agree that you have a driver's license in the state of Idaho. I agree. We all agree these things. Now, if the set of people agreeing is going to be an open set, in other words, if you wanted to join this agreement, you could just install software on your computer, and then you'd be a part of this global agreement over money or over identity. If it's open, it's going to need an incentive mechanism to make people want to participate in that consensus, which is otherwise computationally somewhat intensive, which is otherwise something that you want to make sure you only have serious people participating in, not just somebody who's spun up a bunch of bot computers, but people who are actually investing in the security of the network. And if it's going to be open, and with a way to incentivize participation, it's going to have this token, this scarce token that is determined by the network that rewards people for participating and allows people to come and go freely. So the Bitcoin blockchain is a great example. The only way to write additional data, non-money data, to the Bitcoin blockchain is to make a Bitcoin transaction. It may involve a de minimis amount of Bitcoin, but there will be Bitcoin there. And as we were just saying, even though that may be something, like there are really cool applications here, like maybe we can chart attribution of movies and music and have a record of that we all agree on, or maybe we can do identity or the Internet of Things uses. But no matter what, if every transaction involved a movement of some money, then maybe every use case, technically, in a really close reading of every state's different money transmission statute, of FinCEN's virtual currency guidance, maybe every one of those applications actually involves money transmission. Now, if it's a closed ledger instead of an open one, you might be able to avoid that problem. But what have you given up in return? In some ways, maybe you've created the same sort of siloed structures. Only these members are allowed to participate in the agreement. The same siloed structures that we currently have with cloud computing, where, yeah, Google helps us all come to an agreement as to who's allowed to edit a Google Doc, but it's all happening on Google servers.
So I do want to talk a little bit about this idea of like permission blockchain. We've been talking a lot about disclosures and fairness, and in terms of a permission blockchain, if individuals or private companies are getting together to create a permission blockchain that's closed off, one issue to think about is data security. This goes beyond just disclosures. We would look at whether or not these groups of entities are taking reasonable measures to ensure that consumers' data is being secured. Because even if you have a permission blockchain that's closed off, it's still rich with all sorts of consumer information, and that's something that should not be overlooked.
Helen, though you also have the issue with permissionless players or players in the permissionless system. If they're collecting data from individuals, they have the same kinds of obligations to protect that data.
For sure, but I used a permission blockchain example because that's usually easier to like point out the specific actors, but you're exactly right. Even in a permissionless blockchain, whoever's collecting all that data, they still have an obligation to protect the consumer's information.
I think it's also interesting to note for the audience that to the extent that we've got young companies in particular in the audience, is that the FTC is paying attention to what steps you're taking, the disclosure steps that the companies are taking from the time they begin operations. up through several years into business. And the Dawala case was a recent example of that, where data security promises had been made but had not been upheld by the company.
Right. That was the CFPB case, but the idea behind that one was about disclosures. So Dawala made representations about how secure the consumer's data was. I think they made representations about bank-grade security, and it turned out that wasn't true. So in that case, it was less that Dawala did not take reasonable steps to protect consumers' data. Maybe they did, maybe they didn't. I don't know. But the case was about what they said to consumers and whether or not they followed through on that representation.
And Rose, one of the issues in the CFTC case against Bitfinex, I found of interest was they took note of the fact that Bitfinex was registered as a money service business, and it seemed that the CFTC focused on a very narrow issue when there may have been other regulatory issues to be dealt with, maybe by other regulatory agencies. Is there any light that you might be able to shine on that for us?
Well, yes. At the CFTC, we have various departments, and the particular department we're talking about is the Enforcement Department, which focuses primarily on law and looking at the law per the Commodity Exchange Act, which is in our jurisdiction. So they basically have to look at the narrow definition of the particular case instead of looking at, say, other regulators like the Securities and Exchange Commission, which has other type of law and jurisdiction within their purview. Basically, that's how it works. You don't really want to go into either the Federal Trade Commission or the Securities and Exchange Commission's laws. You want to basically focus on what your jurisdiction is. So that's primarily why it was so narrowly looked.
So, Brian, how are we going to fix all of this?
Well, so, I mean, I think there are a few, I am not so optimistic to think there's going to be a fix, but I think we can improve our position a little bit. There is some effort at the state level with the CS, Conference of State Bank Supervisors and Uniform Law Commission to work on a couple, to try to bring some more uniformity and coherence to state money transmitter regulation. There's a uniform law that's being drafted, and the CSBS is working with state regulators. Of course, the uniform law doesn't have any force on its own. It requires the states to adopt that as their own state law. And even then, I'm somewhat pessimistic because I don't think you're going to get all 50 states adopting. I think they're going to, even the ones that do, they're going to put enough unique variation on it, enough homegrown spin on it to make it at least difficult for companies to rely on the notion of, well, these are all uniform law states, so we're good. You see this with a lot of state money transmitter laws that they defer a lot to the corporate commissioner or whoever the regulator is, where there's language in the law that says, well, whatever this entity thinks is reasonable, and of course that can be hard to predict. And then layer on top of that the multiple federal regulators and the multiple federal laws. I mean, it's possible, given the fact that we're talking about something that looks like money in some respects, the CFPB under Dodd-Frank might have a lot to say about this eventually. And they have a lot of relatively unbounded authority. So what I think would be good is for us to acknowledge and for lawmakers to acknowledge that Bitcoin as money has changed the way things get done, so that it used to be hard if you weren't a large player to operate over a wide space. And now it's hard not to operate over a wide space. Now it's hard to say, well, okay, look, we're not going to take business from Arkansas. We're going to have to geo-fence around Arkansas because we're not, we don't think we're compliant there. And that's a lot of hard work. Whereas in the past, unless, if you were a small business in, Virginia, getting into Arkansas would be really hard. And why would I ever do that? I don't have business there. It would be hard to get customers there, whatever. Now, with the internet, with the distributed nature, it's hard to not have customers places. And so that I think should affect our view of law and how regulation should be done. I think there are things the federal government can do. I mean, obviously the biggest one would be a preemptive law. Sweep aside state money transmitter law, at least for virtual currency, come up with a substantive law. That's a big lift, and there are arguments for that and arguments against it. I don't think we're going to see it soon. Yeah. They could also do some things to help either create safe harbors, like create a federal safe harbor to say, look, if it's a de minimis issue, you're not going to be prosecuted. You can't be prosecuted. Federal law prevents the state from prosecuting you, which is a trick but doable. That type of thing, you could do what you see in some banking law, which is say you can export certain attributes of your home state's law outside of the state. So if you are a registered money transmitter in Virginia, you can operate under Virginia law in Maryland, DC, whatever. These are all possibilities. I don't know if we're going to do it.
Peter?
Yeah, so the practical political considerations aside, for me, the two things that I think are really essential to at least work towards, and we can debate whether it's attainable either from Congress or from a uniform law commission that's going to try and get all the state legislatures to agree on something. The key thing to think about is, I think, custody. So custody is this concept that we have in the financial services industry of a moment where you assume a relationship of trust with the customer because you're holding their valuables. That's what makes you either a bank or a money transmitter. That's what makes solvency regulation important, to make sure that you're not actually just lending out too much and you're never going to be able to make good on all your outstanding obligations. Now, in the context of Bitcoin and the Internet of Money, there are parties out there, like normal exchanges, like Coinbase, like hosted wallet providers, who are going to have custody, and they should be regulated like companies in the traditional financial sector for consumer protection purposes, for anti-money laundering purposes. But there are lots of companies. We touched on this with the non-financial uses, so maybe I want to write data to the Bitcoin blockchain that has more, that has identity or other things in it. And there are also de minimis uses where you were really just facilitating a very small amount of money moving. One thing we didn't touch on additionally, for those of you who are familiar with the technology, there's also a concept of divided control, where you have a contract. It's a kind of smart contract that says that 4 of my friends and I need to all vote to move these Bitcoins on the ledger. And maybe a company helped you set up that relationship with your 4 friends, and maybe that company even has one of those votes to move the funds. That company is doing something hugely interesting. It's doing a kind of escrow where you don't need to trust the escrow provider in that sense, or it's setting up a voting rule. Also doesn't seem like money transmission. So we've got these things, very small transactions, transactions that are used to do something non-financial, like put data in the blockchain, and transactions that involve something new as far as divided custody, where you have multi-sig or NLOC, which is another technology that delays through time. These are where there's a lot of innovation. These are where there's so many chances to improve the existing financial infrastructure by spreading out risk, by decentralizing control, by doing things beyond money, like identity or the Internet of Things. These are things that shouldn't be tied up in this very difficult regulatory landscape, if only because they don't present the kind of custodial risks that holding someone else's money normally present, but also because we have a lot of enthusiasm and faith that these new technologies will make our lives better. So defining custody to exclude those 3 things, non-financial transactions, very small transactions, and transactions where no one party really is able to transact unilaterally. That, for me, would be a massive improvement in getting us to a place where an innovator who's doing something not that risky can behave kind of like Uber behaves. Can go out and move fast and break things, knowing that we're only operating in a section that doesn't break too much, that doesn't lose grandma's money.
Well, consumer protection laws would still apply.
Would still apply for a different purpose, though. So there's enforcement actions because your thing didn't do what it said on the tin. And that's always going to apply. But then there's also licensing law, which says you're not even allowed to make a thing unless you get permission from 50 different state regulators.
Yeah, and that's separate.
Totally separate. Yeah, and I totally agree that consumer protection always applies. It's a question of how you architect that.
So we're hearing several things here, and this is part of the problems we've had around this whole subject, because you can see we've got a lot of different things going on at one time. To Brian's point about the Uniform Law Commission efforts, there actually been two. There was a Uniform Money Transmitters Law that was put out back in 2000, I believe it was, 2001, which 7 states, I don't know whether that includes South Carolina and New Mexico, are now on board with regulatory schemes and more adoption in the North Carolina statute, where we've seen those changes just in the last few months. But it is still a very small number of states in a 15-year period who have adopted that statute. And believe it or not, that statute had provision in it for digital currencies back in 2000. So that's a big issue with this new Uniform Law Commission project coming forward. It's probably another year before it's even going to start to get marketed to the states. And based on the adoption we've seen previously, I wouldn't hold my breath that we're going to see too many states move forward.
Although the Uniform Law Commission has a great definition of custody. If this is an issue that you find interesting, they've got the right name.
Great efforts.
Yeah. Well, but thanks to a whole group that's trying to approach this carefully and rationally.
But Peter's a great educator on that.
But as you said, it's a year out from being even presented to the states, and then they'd have to adopt it. So working towards the right things.
So what do we do in the meantime? And I think one of the things, if you look at our two biggest friction points, would be state money transmitter licensing and the FinCEN rules for money laundering, anti-money laundering control. And one of the things to think about as we're moving away from Bitcoin as pure money to being that fuel in the blockchain is that there is an exemption in the FinCEN rules for incidental activities, and that's one to play around with. Been using it with a certain amount of success. I can't say how far out we're going to be able to push it, but it is there to be used. And there is some flexibility with the states as well. The states are not quite as hardcore and rigid on a number of these issues, especially if it's a face-to-face or a internet person-to-person exchange that we're talking about. So I wouldn't despair entirely, would I, in this? I guess my last question to the panel, we could obviously go on with this all day, is should we have a federal commission appointed to come up with a blockchain strategy?
Well, that's up to the voters.
I mean, a more unified approach could be useful, but at the same time, I think the key is just educating regulators in their existing silos and helping them collaborate between each other. And it's most difficult at the states, honestly. So unless the Federal Commission was talking about preemption of state law, which is, as Brian said, a huge reach, I'm not too optimistic about that.
Bruce? Okay.
Well, I mean, I don't know if another commission will do much, but why not? I think one thing that would be helpful is for policymakers and really everyone, because you can't expect the policymaker to be the thought leader on this. They have other things they need to do, but to really tease out all the different use cases, right? Because preempting state money transmittal law is a big lift and has some serious implications. But maybe you can tease out a thread or two that for the concerns of the state, which is fraud, and grandma losing her money or the payment not getting there, aren't really applicable, but for the innovative things that Peter was talking about, the innovative things that blockchain hopefully can really leverage, are huge. And say, all right, well, we're going to carve out this little bit or this little bit just to provide consistency. Because I think that the big challenge, just generally in the states, the number of states exacerbate this, is even if everyone adopted the uniform law, there's no guarantee that they would maintain it for more than a year or two, right? So you're constantly having to monitor all of these different actors. And if you could pare down the number of actors, that is a value in and of itself.
Well, and there's been a lot of discussion over the years about a single money transmission license at the federal level. Mm-hmm. But interestingly enough, what held it back for probably 15 years or so was the fear that if you started that conversation, you'd end up with a lot of consumer protection around it, baked into the statute. Now with the creation of the CFPB and the consumer issues back on the table in a major way, I don't think we have that same kind of consideration. It's the monkey's already on the back instead of trying to keep the monkey off the back. So I guess, do we have any questions from the audience?
I don't think we'll have time because of the.
I didn't see you there.
No, it's all right. So thank you very much for
Thank you.
your session, and a round of applause for the.